There you go.
Okay. And all right, we got two more people coming in. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of inherited property. We're here to talk about clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and also our presenting partners today with the Texas Legal Services Center. We have Ms. Lisa Nelson. Also, on behalf of the Harris Central Appraisal District, we have Ms. Mabel Menifee, as well as Ms. Jamie Duong with the Harris County Tax Assessor Collector's Office. In addition to that, the other partners also include the Earl Carl Institute, Houston Volunteer Lawyers, Lone Star Legal Aid, and the Houston Bar Association. And together we make up A Month of Service. And basically what A Month of Service is, it's the collaboration of all organizations listed there, and we provide resources, workshops, information to the community relative to asset protection, asset building, the maintaining of generational wealth, and community empowerment. We started doing these presentations quite a few years ago in an effort to try to reach more people, to create a larger impact, and to try to get as much information out to the communities that we all serve as much as we can. We know that there are a lot of underserved communities that are out there that do not know where to go for particular information, for available resources that can help their particular situation. So again, we chose to come together to try to create a larger impact and do just that. So make sure that we can kind of get that information out to everyone. So the session that we are having here today is kind of like the part two of the presentation from last week, which was the wills and estate planning and how to create your own documents that make up an estate plan. So this is kind of what happens after when someone else actually passes away and they don't have a will, or if they do have a will, what is the probate process actually like? And what does it mean to be an executor or an administrator for someone's estate? Or if someone passes away and there are multiple heirs for property and don't know what to do as far as the distribution goes when you've got multiple heirs, and someone passes without a will, what's that process like? If someone passes away and they've got deferred property taxes that they've had on their property, what does that mean for the actual heirs? What are their available payment options that can help remedy that deferred property tax bill that they've had that have not been paid over a period of years? In addition to that, there are heirship exemptions that heirs can qualify for when it comes to property that they've inherited. And we're going to go over all of that for you guys today. So there's a lot of information that we intend to cover. Note that the information that does get presented here today is for educational purposes. It is not to be considered legal advice. However, we do encourage you to reach out to any of our legal service partners for any civil legal assistance that you all may have or may find yourselves in need. When in addition to that, ask that you pay it forward. You know, if you know of someone else that may also be able to use the information that's presented, then please, share the information. That there are still way too many people out there that don't know what their rights are, and we need to get that information out as much as we possibly can. And do know that everybody's situation is different. No two people's wills or estates or things like that are exactly the same. So what works for one person doesn't necessarily mean that the process is going to be the same for the next person. And you do need to make sure that you contact some legal professionals that can help assist you with this journey, because it is a long process. It is a very long journey. It can be very stressful. It can be very strenuous. But be patient and know that there is a solution for every problem that's out there. So in addition to that, I want to say that this is an opportunity for you all to be as interactive as you like. Please feel free to join into the conversation. If you do have questions, please feel free to type it into the chat. And we will make sure that someone addresses your question either during the presentation or at the end. You do have the opportunity to also unmute yourself at the end and ask your questions directly of the presenter. You also please note that we are recording the session as well as broadcasting live on our social media platform. So if you are joining us online, then please make sure that you type your questions or comments into the comment section, and I can read your question aloud there as well. There were a few questions that were emailed to me when some of you registered, as well as just sent to me in advance, and I will make sure that those questions get addressed at the end as well. So do note that we want to try to protect your privacy as much as we possibly can. So we ask that you try to keep your questions to be as general in nature as to not divulge any personal detail information to kind of get out there for everybody to have access to. So again, on behalf of the partnership, we want to thank you all for joining us. We are going to move right on into our introductions with Ms. Mabel and Ms. Jamie, and then Ms. Lisa will have you introduce and move right on into your presentation to start. So how about that? Ms. Mabel, would you like to introduce yourself first?
Of course. Thank you, Nia. Good afternoon, everyone. Oh, let me there we go. My button's being a little stubborn there. Good afternoon, everyone. My name is Mabel Menifee. I'm with the Harris Central Appraisal District, and I'm going to follow Lisa with a short presentation on the property tax part of it, which in terms of talking about inherited property, also can include exemptions and deferrals. And then just to offer those of you that may not be homeowners or may not be familiar with appraisal districts and ad valorem taxation, a general amount of information that you can reference when you're dealing with a situation, just as Nia described. So I'll see you in a bit and move it on to Jamie.
Thank you, Mabel. Thank you, Nia. Thank you, Lisa. Good afternoon, everyone. Thank you so much for making the time to spend with us today. My name is Jamie Duong. With me on the chat room is Shay Pinkowski. She's with our customer service department. And on behalf of Ms. Ann Harris Bennett, your Harris County Tax Assessor Collector, we want to welcome you to this session. And, you know, whether it be you're planning on an estate for your children, or you're inheriting part of an estate, tax is an inescapable part of that equation. We want to provide you with information that may be helpful and at least offer some guidance for you to make sure that, you know, along the trails, you've got some useful information. So stick with us. Like I say, we aim to provide information. And if there's anything that haven't been presented or you're curious about, type them in the chat and we'll be happy to have an open discussion on it. Thank you.
All right. Thank you. Ms. Lisa.
Thank you so much, Nia, and thank you, Jamie and Mabel. My name is Lisa Nelson, and I'm a staff attorney with Texas Legal Services Center. I work on the Texas Law Help team, and we manage the website texaslawhelp.org, which covers anything you need to know about civil law in Texas, as well as federal law that affects Texas. We don't handle much criminal law. Today, I'm going to talk with you basically an overview of the probate process, as well as what to do with inherited property. So let's get going. My mouse is disappearing here. So this is clearing title and other probate concerns and how to handle inherited property. We're going to start with an overview of probate in general, and then we'll do the purpose of our presentation today, which is how to clear the title when you inherit property. Finally, I want to make sure that you know how to transfer property correctly to your heirs. We want to make sure that you build that generational wealth. And then I'll pass it over to my friends Mabel and Jamie to talk about property tax concerns. Texas Legal Services Center is a statewide nonprofit. We provide legal advice, advocacy, representation, and education to underserved people across the state of Texas. We have more than a dozen practice areas, so our work probably touches, every aspect of law that low-income Texans would encounter. Our mission is to ensure equal justice for all Texans by educating, empowering, and representing vulnerable people while reshaping the greater legal system that impacts us all. So there's a lot of new vocabulary to learn when you encounter probate. Decedent is any person who dies. Testate is a person who dies with a will. A person who dies who did not have a will is considered intestate. Testator is just a fancy word for the person who signed the will. And a will is a legal document which states how the testator's property is to be distributed at death. Estate is your stuff. It's both your real estate, also known as real property, and your personal property that you own, that the deceased person owned at the time of death. Probate is the process of winding up somebody's affairs. It still goes through the probate court, but it's known as administration if someone passes away without a will. The person who is in charge for wrapping up the decedent's affairs is the personal representative. If there was a will, they are known as the executor. If there was not a will, they're known as the administrator. An heir or a beneficiary is the person who either inherits through a will or by law. If there's no will, the laws of Texas determine who inherits your property. Powers of attorney are only valid when someone is living. A lot of people will think, well, Mama didn't have a will, but I was her power of attorney. Once that person passes, the power of attorney is void. You can't use it to plan funerals. You can't use it to get access to bank accounts. It is only valid during the person's lifetime. In Texas, spouses have to have separate wills. And another thing that is a common misperception is a lot of people think, well, I don't need a will because I have a spouse and it's a community property state. So, when they die, whoever dies first, the other person gets the house. That's absolutely not true. Now, if you are in a marriage with someone who owned a house before you got married, that house is their separate property. You will have the right to remain in the home for the rest of your life. You will have to pay property taxes and be responsible for all maintenance, but that house is not yours to sell. It's not yours to give away to somebody else. It would pass to whoever, if they had children from another relationship. And when you were selecting an executor when writing a will, or if there was no will and the family is choosing an administrator, they have to be over the age of 18 and they need to live inside Texas. What's very critical when you have a will that you know and you tell your executor exactly where your original will is. If they cannot find your original will, Texas law assumes that you tore that will up to revoke it. In Texas, you can prepare your own will, but it's really best for an attorney to prepare your will, or at least have an attorney read through your will to make sure it's okay. A lot of people think that, well, I can get a form from LegalZoom or another website for $100. Why do I need to pay an attorney? Those forms aren't valid. I can tell you many stories where people were trying to save some money and all of the money ended up going to the lawyers and the courts because a lot of the online wills are not made to be compliant with Texas law. They're as general as possible, and Texas law has specific requirements for wills. We do on our website have forms that you can use. They've been approved by the Texas Supreme Court, and they're pretty straightforward and easy to use. Even those, it's a good idea to have a lawyer look it over. Texas law allows you to write your own wills. It's called a holographic will. And we have instructions on texaslawhelp.org for you to do a handwritten will. If you follow the Texas law, your handwritten will is valid. And as I said earlier, please let your loved ones know where your will is. And if you have a safe deposit box, don't assume that just telling your executor, the will, all my papers are in my safe deposit box. If they're not on that safe deposit box account, the bank cannot legally let them access those papers. If you die without a legally valid will, the law determines who will inherit your property. It's not who you wish to inherit your property. If your loved one if you can't find your loved one's will, or you know for a fact that they didn't have a will, you can file an application for administration. Depending on the circumstances, you can either file for dependent or independent administration. You want to talk with an attorney to find the best way to proceed, because Texas has a lot of different options for people who passed without a will, and they will know the most efficient way to do it. In extremely limited cases, you can have a small estate affidavit, but it's very limited. And I'll go over that in just a minute. Probate assets are the property in your name that passed under the will. That could be your house, your real property, and it's also your personal property. It's your household items, furniture, clothes, all your stuff. Texas also has what's known as non-probate assets. Those do not pass through your will. They pass in accordance with the terms of a contract. Common examples include life insurance policies, retirement plans, and payable on death accounts. I have a great tip for everybody here. If you have payable on death beneficiaries on all your financial accounts and a transfer on death deed for your house, your family may not need to probate your will. I'm always going to tell you to have a will because it's just a safety, it's a safety net. But if you take the time to call your bank, to call any financial accounts that you have, and make sure that you have payable on death beneficiaries, they'll be able to inherit that property a lot more quickly, and it'll be a lot less expensive than probating a will. Small estate affidavits are only appropriate in limited circumstances. A small estate affidavit can be used to transfer real property only if it is going to be inherited by a surviving spouse or child under the age of 18. You cannot use a small estate affidavit to transfer real property if there's only an adult child. Even if the adult child lived in the house with their parent, took care of that parent, they cannot use a small estate affidavit. The other requirements are that every single heir has to sign the small estate affidavit along with 2 disinterested witnesses. The witnesses are people that knew the person who passed away, but they don't legally inherit from that person. You cannot do a small estate affidavit if the deceased person left a will. Or if you can, if the will wasn't legally valid. If it's a will that doesn't meet the requirements of Texas, you could do the small estate affidavit. The value of the assets has to be greater than the debts of the estate. So say somebody passes and they have $20,000 in car and furniture and all that type of property, but they've got $40,000 in credit card debt, they cannot use a small estate affidavit. And importantly, the estate has to be less than $75,000. That does not include the value of the homestead. Your home is exempt. So it's the same process whether you're probating a will or having independent administration. The attorney files an application to probate or an application for administration. After 10 days, the attorney schedules a hearing with the court. This does not mean that it happens that quickly. In Harris County, it can take 6 months to a year before you can get in front of a judge. Our courts are just that busy. The judge will grant the application, and the personal representative receives letters. They're letters testamentary if there was a will, and letters of administration if there was no will. Those letters are their court permission to do everything they need to do to wind up the estate. Once you have those letters, you can access funds in a bank. You can sell any property that they had. So then it's the personal representative's job to gather all of the assets. They also have to open a bank account for the estate. They can't just reopen the account that the person used before they passed away. They have to open an account that's in the name of the estate. The attorney will notify any creditors of the estate. Now, one thing that's really important, your personal representative is not personally responsible for the debts of anyone who passed away. Those debts are paid out of the money that the deceased person had on hand, out of their assets. And then the attorney and the personal representative prepare and file an inventory. The inventory is a list of everything that the person owned as of the date of death. Now we're going to go over how to clear title to inherited homes. It's really important if you live in a family home to make sure you have clear title. If you don't have clear title, you do not qualify for any type of assistance if there's a natural disaster. You're not eligible for property tax exemptions or deferrals if you're not the owner as well. A lot of times what happens is people have been living in a family home and we have a hurricane or we have a winter storm and they have some serious property damage. So they go to FEMA or they go to a state program and they apply for assistance, and the people are not able to give you any type of assistance if the home does not have clear title. Clear title means that no one else has a financial interest in your property. It also means that there's no question of ownership and you can easily tell the ownership history of a property. When property is not legally transferred or deeded to the subsequent owner, the title becomes cloudy. This happens when somebody dies without a will or the family doesn't manage the estate. A lot of people want to know, after I've assisted them with getting a clear title, they want to know when they're going to get a deed, or when they're going to get a new title. Title is the name for the right to the property. The deed is the piece of paper that conveys that right. The deed is the piece of paper saying this house belongs to Nia Murray. Real estate title is not a physical document. It's the strength of your ownership claim. So having clear title means there won't be any unexpected valid claims on the property. That means there's not going to be any liens on the property. There's not going to be any question that it is 100% owned by Nia Murray. And a deed is the document that transfers ownership to the new owner. Another thing that's important is to make sure that you keep your title clear. The best way to do that is to file a transfer on death deed. It's the easiest and least expensive way to transfer real estate to someone after you die. A legally valid will also transfer property after you die, but the transfer on death deed will save your heirs a lot of money and a lot of time. In Harris County, we're looking at 6 months to a year to possibly probate a will, and even longer, to probate a will, to transfer title to whoever is inheriting the house in that will. If you have a transfer on death deed, it's a very simple process. Just takes hours. Like I said before, it's really important to have clear title so you can get disaster recovery assistance. You can also get property tax exemptions and deferrals. You can get home improvement loans, other types of home improvement. And if you have clear title, you can get any type of loan on your property. I'm telling you all these ways to avoid probate by having transfer on death deeds and payable on death beneficiaries. The one thing that is still critical, if those things don't exist and the family just continues to live on the real property, they might not have clear title, and they certainly might not be able to access financial accounts if they don't probate their loved one's estate. There's three ways that you can possibly clear title through the court system. If it's within 4 years of the date of death, you can probate the will, or you can file an application for administration. If it's been more than 4 years, in some circumstances, you can file an application to probate as a muniment of title. That requires that every single person agrees with the contents of the will. And even though you can do it more than 4 years, it can be a real headache. I had a situation where this gentleman owned a house with his mother-in-law. She passed away in the 1980s. They never probated the will because they didn't think they could. Now, 50 years later, we are having to track down every single family member. And because it's been 50 years, there's probably 30 to 40 family members that we're having to track down to get approval to probate that will. The other option for certain people is to do what's called a petition for adverse possession. So if you have a will, or you're able to do an administration, the judge approves the process and you're able to clear title fairly quickly. By fairly quickly, I mean within a few years in Harris County. If it's been more than 4 years and you want to use the will as a muniment of title, the homeowner must have left a legally valid will. Every heir must agree to probate the will. And that's not just the heirs named in the will. That's the people who would inherit the property if there were no will. Once the judge admits the will to probate, you file a certified copy of the order signed by the judge and the will. And once those are filed in the deed records, the property is owned by the person named in the will. Adverse possession is something that you've probably heard about. It's a legal principle that allows a person to obtain ownership of a property based on continuous occupation without permission from the legal owner for a specified length of time. You cannot get property if you have permission to live at that property. I had a situation where someone came to me. She was the only one living in the heirship property. No one else would sign away their rights to the property. She could not use adverse possession because she had permission to live there. They told her, you can live there, that's fine. We're just not giving you our rights. You usually have to live on that property for at least 15 years. The easiest examples of this would be people that have a vacant lot next to their house and they keep that lot cleaned up. Maybe the neighborhood kids play on the lot or they have a garden on the lot, but everybody knows that they're the ones who maintain the lot. They're the ones that pay the property taxes, do all of those things. That's a situation where adverse possession works well. Okay, this is the easiest way to clear title if you're not able to use the court system. This is an affidavit of heirship. You can absolutely do that without a lawyer. It is a legal document that you use to give property to people who have passed away. It can be used if the homeowner did not have a will or it's been more than 4 years since they passed away. It has to be signed and notarized by 2 people who knew the deceased person and their family history very well. So it can be a neighbor, a church member, an aunt, somebody further, not the direct descendants. You absolutely must include the full legal description. The legal description on your property tax bill is not the full legal description. You need to find the deed. If you don't have a copy of the deed, you can ask the county clerk's office to look for it. There's also a website called texasfile.com, and you can look for your deed online there. I've used it, and it's pretty easy to search, and I believe it costs the same as the clerk's office, which is $1 per page. Once you prepare that affidavit of heirship, you need to file it in the county where the property is located. There is a filing fee that varies by county. Harris County is a little bit more expensive. I think it's $26 for the first page and then $4 for each additional page. So you're looking at least a $30 fee, but going to probate court is going to be more than $500. I know I haven't checked Fort Bend County lately. I believe that their filing fees are slightly less expensive. Some people get confused about the difference between a small estate affidavit and an affidavit of heirship. They're both affidavits. You can only use a small estate affidavit to transfer real property to a surviving spouse or surviving minor child. If you don't need to clear title, but you need access to a bank account or a savings account, something like that, the financial institution may let you use a small estate affidavit to transfer those funds. You can check with them to see. Affidavit of heirship is used only to transfer a home to adult children or other people who are entitled to the home. If there's no other assets in the estate, you can use an affidavit of heirship to transfer the home to a surviving spouse. I always get on my soapbox after this and talk about how you want to make sure that it goes more smoothly for your family. A transfer on death deed is a simple, inexpensive way for a homeowner to transfer a home or other real estate to someone else upon their death. You retain 100% ownership during your lifetime. You can still sell the property. You can still use it as collateral for a loan. You can still get your property tax exemptions. The beneficiary has absolutely no rights until you pass away. You can also change who the beneficiary is or cancel the deed entirely. The deed must be filed before you pass away or it's no good. We have a toolkit at Texas Law Help. This is just the first screen on it. It will walk you through the steps to prepare a transfer on death deed. Just like I said with the affidavit of heirship, it's really critical that you use the correct legal description. If the legal description isn't correct, your heir is going to have a cloud on the title. They will not have a clear title, and it will take some work to clear it up. One of the other great things on transfer on death deeds is it protects your property from Medicaid estate recovery. A lot of us will use Medicaid to pay for our nursing home care. And once a person passes away and their spouse passes away, Medicaid can try to get reimbursement by forcing the family to sell the house. They can only do this if you probate the will. They can't do it if you transfer the property through a deed. So besides saving your family the thousands of dollars from probate and the possible years of time it would take to go through probate, with a transfer on death deed, it's a very simple process. Once someone passes away, you prepare an affidavit of death. You take that affidavit of death, your ID, and the death certificate to the county clerk's office. They will record your affidavit of death, and the property is yours that afternoon. And it's also, at most $50 versus, I don't think you can probate an estate anymore for less than a few thousand. So it's saving a great deal of money. One of the great things about our month of service partnership is we have a lot of legal resources for the community. My website has a lot of information. We also have attorneys and law students that are available to chat with you. If you qualify, we give you free legal advice. We can give any citizen of Texas free legal information. Earl Carl, Property Preservation at TSU, is a great resource for anything related to homeownership. And they also do landlord-tenant work. They can help with estate planning and clearing title. Lone Star Legal Aid is a fabulous legal aid association that also provides free legal assistance in a large variety of areas. And Houston Volunteer Lawyers also. Legal Line is a program through the Houston Bar Association that allows you to speak with an attorney for free for 30 minutes. Go to the hba.org website and you'll see how to sign up for Legal Line. And finally, Houston Lawyer Referral Service can give you referrals to attorneys who will give you a 30-minute consultation for $20. Thank you very much for your time. I really appreciate it. I'm going to pass this over to Mabel, and I'll be here at the end if you have any questions.
All right, good. Hello again, everyone. I'm going to get my slide presentation up and going for you.
And while Ms. Mabel's doing that, I want to remind you guys, you have the opportunity to please put some questions into the comment section if you have any specific questions that you would like either of the presenters to go over for you. All right, Ms. Mabel, you're good to
All right,
go.
I'm good to go. Okay,
Yes,
well,
ma'am.
as Lisa alluded to, property taxes, exemptions, and those kinds of things can play an important role in the clearing title process and making sure you have full title on inherited property. So what I want to do briefly today is to go over that property tax, the property tax system as it relates to those issues. Just so you'll kind of know what's going on, how to react in that space, and also to talk about exemptions and how some things may appear the way they do when you start to try and transfer title. So we'll go ahead and get started on that and just kind of give you a quick overview of, okay, it's not wanting to advance. Oh, there we go. So just quickly, property taxes are, you may hear them called ad valorem taxes, but basically in Texas, property taxes play a critical role in funding local services. And that's mainly because Texas doesn't have an income tax where there's additional money to be shared from the state level. So they're going to support the schools and the fire departments, police, county, a number of taxing jurisdictions. And in the case of Harris County, there are over 500 taxing jurisdictions. So appraisal districts like Harris Central are there's one in every county in the state, and that includes, and they all handle the process of property tax valuation for tax purposes. The appraisal districts in Texas are going to appraise for residential property as well as commercial, and that's businesses, apartments, etc., agricultural, industrial, and something called business personal property. And they're required to do so each year annually at 100% of the market value of that property. And market value basically means what that property is worth in terms of what it would sell for on the open market to a willing buyer. So we do that appraisal each year, January the 1st. So every year the property is reappraised, and sometimes it may go higher based on market conditions, and sometimes it could go lower. The other thing that HCAD does is that we administer exemptions. We're going to talk a little bit more about that in a minute. And then finally, we certify the appraisal rolls, allowing taxing jurisdictions throughout the county to then set their rates, because as we certify that roll, they then know how much value there is in the property that for taxation based on their rates. They'll either adjust their rates or they will, and usually then they will send out the tax bills, which you may have noticed if you are a homeowner have started to come out now that the election is over. And that's why I'm not going to talk a whole lot. I'm going to let Jamie, the tax assessor collector, talk a little bit more about that when I finish. The date of appraisal I mentioned to you, always January the 1st. The other thing you need to realize if you are dealing with a property is that the protest deadline, when we send the appraisals out each year, usually in March, you have until May 15th to protest if you disagree with the value. For some reason, you think that the valuation that HCAD provided on the property is incorrect, you do have the opportunity to protest that value. You have until May 15th to file that protest, or 30 days from the date of the notice that listed on the valuation letter, whichever one of those comes later. And then in August, and this is one of the reasons why this is a annually rotating cycle, and why there are deadlines for certain things, because we do this each year for the taxing jurisdiction so that they can set their rates. But in August, we certify those appraisal rolls for all of the taxing jurisdictions. And by the way, there are over 500 here in Harris County. It just depends on where you live, which ones you pay to, which are usually 4 or 5 of those. Again, tax bills are now being mailed out. This is the season for that. And then any taxes that are not paid by February the 1st become delinquent. We are required to be at 100% market value, and just so you know, there are over 1.9 million parcels of property in Harris County. I did want to mention that each appraisal district has a chief appraiser. Here in Harris County, that is Roland Altinger, and appraisal districts have or will have 9-member boards of directors, 6 of which are elected by taxing no, 5 of which are elected by taxing jurisdictions. The other one is a tax assessor collector, and then the other 3 are those that you vote on in an election. This is what that I mentioned to you, the valuation letters that we send out annually. This is what one looks like in case you're just looking through papers and you happen to see it in the mail, or in case you're getting one. It typically lists the appraised value and the market value. Keep in mind, the market value is what HCAT has determined is going to be what it would sell for, most likely on an open market. The appraised value can be something different, and it may be different because you've got exemptions, and so you're protected from rapidly increasing property values over a single year, and then you also get certain discounts on your property because you have that general resident homestead exemption, or that over 65, or one of the others we're going to talk about. The appraised value, again, just want to make sure you understand that is the number that's used in calculating the tax bills. That's the number that the tax assessor collector is going to use in configuring your taxes. It could be the same as market value if you don't have any exemptions, but it's most likely, for the most part, at least initially, it's going to be lower than that because, again, you're also of the benefits that you get from that, which includes your appraisal being capped at no annual increases being capped at no more than 10% for properties that have the exemptions. The market value, as I mentioned before, is the value at which the property is going to sell, or HCAT has determined it will sell to a willing buyer on the open market as an arm's length transaction. And that's our annual role here at the appraisal district, is to establish that market value. It's also important that whenever you protest, the protests are going to be based on what that market value is that we've determined. Just a quick look at some of I talked about protests, so you can still continue. You may want to protest if you're getting something in the mail that you disagree with, your annual value notice, and you would have several options on how to file a protest. Some are electronic. Some you can meet you can meet informally with an HCAT personnel, appraiser, evaluation analyst, and talk things through and show them your proof as to why you think it should be lower. And that is one way of solving it. If you're not happy with that, or you just want to go full to the formal hearing straight away, that is with the appraisal review board, and that's a group of citizens that listen to your appeal. They listen to HCAT's case, and then they make the decision. They are people who live in the community. They do get some training, and they're kind of like a jury of your peers, if you want to stop and think about it that way. And then, of course, if none of that works for you, and you're still not satisfied, and you want to continue with it, there are other methods that you can pursue, such as arbitration or litigation. You can sue. So I did want to mention too, for anyone who is more interested in what I've just talked about briefly about the protest, we do have a series of workshops that we participate in, that we invite you to participate in the spring as those letters go out, as those valuation letters go out, for you to join in and just kind of walk through how to protest your properties. And you'll find in those particular workshops, we'll bring in the content experts like appraisers and valuation analysts to sort of help you understand that process and how to protest. So the one thing I did want to talk about, and let's get right to it now, are exemptions. And it's important to understand that exemptions are discounts that property owners are eligible for based on their individual qualifications. So what I'm trying to say there is that you may not be eligible for the same exemptions that the previous owner might have had. So it's important, particularly when you're moving in, if you're moving into inherited property and you're in your mid to late 30s, and that individual that you inherited the property from is over 65, they may have benefited from substantial exemptions that you may not have been eligible, that you would not be eligible for because perhaps you are not over 65, and maybe you don't, that's not your general residence, that which would allow you to apply for the general residence homestead exemption. Perhaps you have another home where you already have it. You're enjoying exemptions on that home. So those are some of the things that need to be considered. I think Lisa mentioned that there's always, it's always tragic when you have individuals who didn't know that, and they may have lived in a property for 4, 5, 6 years or even longer, and they never changed the deed, the property, and which means more than likely they were paying taxes or they were getting exemptions that they were not eligible to receive. And in some cases, the state can likely go back at least 5 years to collect that unpaid taxes that you were not billed for, because even though you weren't eligible. So as I mentioned before, the exemptions, they exempt a portion of the property value from taxation that's on your primary residence only. And this is that once those exemptions have been subtracted from your tax bill, that is what's going to be used by the taxing authorities to calculate your property tax bill. The most common ones are going to be the general resident homestead exemption, and this is available to anyone who owns and lives in a property, and they have the title of it. So that's the general resident homestead exemption. Then following that, once you turn 65, you get an add-on called an over 65 exemption. Over 55 disability, there's some disabled veterans exemptions, and as well as other service-related exemptions, all of which can be found on our website, or you can also find them on the state's website at the state comptroller's office. The general resident homestead exemption is very simple to obtain if you own and occupy the home. The home is owned and occupied. It requires some documentation, basically, of course, proof of ownership, and we do require that you provide the driver's license, your driver's license, or driver's license of the owners, in the event that you are a married couple. We need and it's a 50% ownership between the two, then we would need both driver's licenses, but they must match the address of the property. And that's going to help you kick in certain benefits to owning that property, like that 10% appraisal increase cap, which means that in times where property values are rising rapidly, they may be rising as much as 15 or 20% in some cases, as we've seen recently. You will never be your appraised value, I should say, will never increase more than 10% annually. So it caps it at 10%. You also receive a $100,000 school tax exemption, and that's a state law, not just with local school districts. All school districts in Texas have to do that. And that basically means if you have a home that we valued at $300,000, your taxes for that for your schools are only going to be based on $200,000. So you're getting that discount of $100,000 worth of value that will not be taxed. There may be other exemptions, and there are other exemptions offered by various jurisdictions, and that just kind of depends on where you live in the county as to which jurisdictions offer what discounts. Harris and Jamie's going to talk a little bit more about what Harris County offers if you live in the county. So the over 65, as I mentioned, is an add-on for that you'd qualify for the entire year that you turn 65. So if your birthday is December 30th of this year, and you're turning 65, then you'll get the exemptions for the full year. Now, you may, because of the lateness of the year, it may come in the form of a refund, but you are eligible. That person who was 65 this year is eligible for those. You also can qualify for the person can also qualify for something called a disability exemption, very similar to the over 65 exemption in terms of its benefits. In order to get that, you do need to be declared disabled by Social Security, or if you're not on Social Security, we do have an option that you can provide, a physician can provide a statement to that fact. And those statements, actually, we do have forms for those as well on our website at www.hcad.org. Several important benefits of having that over 65 exemption. Again, and this is why it's important to know why someone who may have been living in a home who passes away may have been paying substantially less taxes than someone even living next door to them. You get something called a school tax ceiling or freeze, which means the year they turn 65, whatever you're paying in school taxes is frozen at that amount. It won't go above that. It can go lower if the value in that is determined to be much lower. The market value drops on that particular piece of property, but it can never go higher unless you do something to substantially improve the market value of the home. And by that, I mean you build a swimming pool or tennis courts, or you've added an additional room or two. That then requires that the value be reset, and then the freeze will be placed back upon that. We also get all of the exemptions that I mentioned with the general resident homestead. And then you're eligible for something called a tax deferral, and you can pay taxes in installments if you're over 65 without the penalties that you would normally incur when paying late. There are other additional, again, depending on where you live, there may be other exemptions that would be granted for the over 65. And I wanted to go over that just real quickly. One of the things I wanted to mention was that, and before I get to that, there's also something called a over 55 surviving spouse exemption. So basically what that simply is that if the deceased spouse died in a year in which they were qualified or already had the over 65 or disability exemption, and the surviving spouse is at least 55 years of age or older on the date of that spouse's passing away, they are automatically eligible to continue receiving those over 65 benefits. We do ask that you kind of alert us to that, because records in Harris County weren't always complete, and depending on how far it goes back, your age may not be shown on the records that we do have. So it's always, for anyone who is in this situation, it's always a good idea to just notify the appraisal district that the ownership has changed. The school tax ceiling continues, and you can, by the way, transfer it if you decide to move. And you're also eligible for over 55 person can be eligible again for the tax deferral and paying those taxes in installments with no penalties. Now, this particular one, I want to just spend a couple of minutes on explaining. It's called the heirship exemption. And this one is for individuals who may live in a property where there are several heirs, but they may be living in it as well. And so what this particular provision of the law allows is for that individual, after following certain additional steps, they are eligible to obtain the homestead exemption at 100% of market value. Now, why is this important? Because previously, until this law was defined, if you lived in an heir property and say there were 3 other heirs, you would only be eligible, and the other 3 may be living somewhere else and maybe had their own homes with their own homestead exemptions. But because there were 4 of you who were heirs to the property, you were only eligible for 25% of an exemption, not 100% of it. But what this particular provision allows you to do is, by taking a couple of extra steps, such as providing an affidavit establishing your interest in the property, letting us know if any other heirs live in the property as well, and getting affidavits from them, copy of the latest utility bill from the home. And people ask, well, why do you need that? And that's just basically to establish proof that the home is being lived in. And then a citation of any court records, if you can find them, that sort of show your ownership, your record relating to your ownership in the property. Again, it may sound consuming, but for anyone who is interested or may be in this situation, please don't hesitate to give us a call. Call our exemptions department or contact our exemptions department, and they will be more than happy to help walk you through how to take care of this and get that 100% exemption if you are an heir. And this one just kind of threw in here, it's fairly new. I don't know if anybody listening on the call needs it, but it's called an immediate resident homestead exemption. And it's really going to be for folks moving into new homes or homes that were previously rental, where there were no exemptions on the property already. Used to be you had to wait until January the 1st to apply, because you had to live in it for a full year. Now, based on legislation back in 2022, you can qualify for prorated exemption upon moving into the home immediately. So if you moved into the home in May, then you would qualify for 7 months of exemptions of the exemption percentage. It's important, though, that you do this. If you qualify, you have to do it before the first anniversary of the date that you moved into the property. So the immediate resident homesteading bill exemption, that's something new. And it's also important to remember that if the home was previously owned and receiving exemptions, the previous owner's exemptions will remain on the property for the remainder of that year. But that's okay, because you're going to be benefiting from the exemptions that the previous owner had on it. In some cases, it could be over 65, and maybe you get a little extra benefit because you're not quite there yet. So one thing I want to point out before I turn this over to Jamie is that there's always some confusion about exemptions versus deferrals. And I just want to put this slide together to show that exemptions are a discount on your taxes. It's a discount that does not need to be paid back. Deferrals are something different. Deferrals mean that you've postponed your taxes, and at some point they're going to be due. They're going to be due after the homeowner passes away, and Jamie will talk a little bit more about that. But the reason I wanted to bring that up as well is because some people, there's a lot of confusion about discounts versus deferrals, and there's some people who may be afraid to apply for their exemptions because they've kind of heard different things out there in the community, and it's, well, you're going to have to pay that back. No, you're not going to have to pay your over 65 exemption things back. The deferral, if you are on a deferral, you will need to pay it back, but not having those exemptions. Once you qualify for those, then they are yours, and you do not need to pay anything back on exemptions, as long as you were qualified for them. So quickly, how do you apply for them? You can do it online, mobile app. You can do it through email. You can email us. And depending on when they were submitted, if it's a busy time of year, it could take a little bit longer. But one thing we implore you to do is to try to submit everything at once to avoid any delay and any risk of having to go to the back of the line once again as you await your exemptions approval. To do that, make sure you submit all of the paperwork. And again, one of the things people tend to leave out the most is they don't include that driver's license that matches the address of the property. And you must do that. If there's a couple ownership, if dual ownership, then we need both driver's licenses, just so that you remember. And if you're still confused about what you need to do, or you're just passing this information along to someone else, make sure they know that they can go out on our website at www.hcad.org. And there is a how-to video when they get to that form online that will walk them through the process of filing for an exemption. And they can do so as they fill out the form. Also, just want to caution everyone about things that you might get in the mail that solicitations that may say, oh, we'll get you a designation of a homestead for free. Basically saying we can save you money because we can get you a homestead designation, or whatever different terms they may use for that. I want everyone to know that getting that exemption is free to the property owner as long as you go through HCAT. As I mentioned, go to our website, fill out the forms, and submit those with the appropriate paperwork. Doesn't cost you a thing. So just be wary of some of those. They may charge, in some cases, they'll charge $45, $50, $75 or even more for that, and you don't have to pay that. So quickly, if you're wondering, if you're wondering whether or not you have all your exemptions, well, each year we send out in late December, early January, this card. This is a one-sided card, but it shows both sides. It shows the information about your resident homestead exemption. It's going to show that we show that you have X type of exemptions, homestead exemption on the card. If in fact you get that and situation has changed and the either that person no longer occupies the house who would have been eligible for those exemptions, you would need to contact HCAT to make sure that that is cleared up. Also, if you are in the home and you do qualify for the exemptions and you don't and you've been getting this, but you don't remember receiving it in a particular year, like I said, usually around December or early January, then it doesn't hurt to just give HCAT a call and say, hey, just want to make sure all of my exemptions are in place, or you can go out on their website and check that as well. Because what happens is a lot of these are go through the mail, and they are not there is no forwarding allowed on these. So if they don't get to you, they're going to come back to HCAT, and personnel here will make a couple of attempts to contact you in other ways. If they're unable to contact you, then these exemptions could roll off. You could lose them and have to reapply. So just keep that in mind. And generally, you get these in December or January. You see it's right, just throw it in the drawer. If not, if you don't recall receiving it, give us a call. And then finally, this is just something I think many of you have heard about. This has to do with a circuit breaker for people who own property that is not homesteaded, such as rental property or whatever. And they added this year where they actually get a 20%. They call it a circuit breaker, but it's similar to what a homestead cap is for that 10% for your residential property value. And not to confuse anyone, if you're not the owner of rental property or whatever, this doesn't apply to you. But it is important to know if you do have rental property. This is what our this is what our website looks like when you go on our landing page. And up here under the second blue line here, the lighter one, where you see property search, if anyone's interested in checking on their exemptions, since we've been talking about them, you can actually go out there and type in your address or account number and make sure and see that your exemptions are in place. It's going to say residential homestead, if you have the general resident homestead. If you have more, if you have the over 65 or a disability, it's not going to say that you're over 65 or that you're a disabled person, because we are not allowed and just do not put that kind of personal information out on a public website. But it will say multiple after residential homestead. So that lets you know that those additional exemptions are in place. Again, if you go under forms, you can pull up all the forms that you need, and that includes the exemptions, corrections, or whatever you might need for sending that into HCAT, many of which are fillable that you can fill out online and send in directly. So again, this is what the front page of our website looks like. And this is just some basic contact information, where we are on the Northwest Freeway at the Hollister-Tidwell exit. If you prefer or need to come out to visit us, our general phone number. Again, our website that I just showed you, www.hcat.org. And then if you want to contact us, you can also go out on this contact us form and fill that out. It'll send that information specifically to folks who will be able to answer your questions online. And that's about all for me today. I hope this was helpful in trying to paint that picture of the importance of maintaining clearing title on inherited property, particularly when it comes to the property tax system here in Texas. So I thank you for joining us. And now I'm going to turn it over to the most popular people this time of year, the tax assessor collector's office. I love saying that.
Give the crown to the appraisal district and the law firms.
Right.
Thank you, Mabel. Thank you, Nia. Thank you, Lisa. Thank you, everyone, for making the time to join us today on our workshop. My name is Jamie Duong. I'm with the Harris County Tax Office, and with me on the chat site is Shay Pinkowski. She's our Assistant Manager of Customer Service. So if you have questions on what our presentation is, or if you have some stuff about your inherited property, please tap them into the chat box, and we'll be happy to address that for you. You know, Mabel's right. It is a very popular time for the tax office because supposedly, actually after tomorrow, you're going to start seeing your tax bills in the mail. And so a lot of fun, a lot of fun. But, you know, for us, our goal here is to provide information. And, let me see. Let me get my... Okay, everybody sees me. Our goal here is to provide you with information so that when you get that tax bill, whether it be from a piece of property that you've inherited or from a property that you plan on putting it into your state for your heirs, at least you have information to be prepared for. Okay. So without further ado, let me start the presentation, and then we have the end of the sessions to answer your questions. Again, on behalf of Ms. Ann Harris Bennett, your Harris County Tax Assessor Collector, I want to welcome you to this inherited property tax session of the workshop. Okay, a little bit about the tax office. You know, we collect over $8 billion for Harris County taxing units, and of those, maybe about 82 taxing units, and it keeps growing. But as Mabel had mentioned before, there are over 500 taxing jurisdictions in Harris County. So the tax office collects only a small fraction of that. But that fraction amounts to, for example, the taxes for your City of Houston, your Houston Independent School District, your Department of Education, Flood Control District, and so on and so forth. As you know, with the recent election, we had some rate changes, and we had some legislative changes that impacts your bill. And I'll go a little bit further into that in the presentation. But some basics as far as how are the tax bills calculated. The first part, which has already been presented by the Harris Central Appraisal District, this is the determination of value. Okay, this part is a collaboration process between the property owner and the appraisal district. Okay, as Mabel had mentioned, the property are usually appraised at market value, or are always appraised at market value, unless there are changes in conditions that are brought forth to present as evidence. Then the property is what it would normally sell for in an open market. So the property owner and the appraisal district settles on the value of the property. The next step is the determination of the tax rates. Now, recently, a lot of the taxing units have rates elections, and this is set. Usually the tax rates are set by the governing bodies, and for Harris County, that's the Commissioner's Court and the governing bodies of each taxing units. Now, the rates have been completed, and then, of course, the last part is where the tax office plays in. We take the value, we apply any applicable exemptions you may qualify for, that you filed for with the Harris Central Appraisal District. We apply that, and then we come up with the taxable value, which we multiply that by the tax rates, and produces the tax bill. Like I said, this week we've done our final bill review, and the bulk of the bill will be starting to be mailed out by next week. Now, if come November, end of November, early December, you still haven't received your bill, check online. More than likely, if your bill has been certified and we've have a calculation for it, then the bills would be available online at www.hctax.net. And if all fail, reach out to the tax office, send us an email, give us a call. We'll be happy to send the tax bill to you. Now, I mentioned earlier about some of the recent changes that may affect your property tax bill. First of all, Harris County has increased the exemption amount for properties owned by by owners that are over 65, disabled veterans, or surviving spouses that are 85, that are 55 years of age or older. So Harris County has increased this exemption amount from $275,000 to $320,000. Okay, the city of Houston has done similarly for property ownership for those owners in similar category of, over 65, disabled veterans, and surviving spouses that are over 55 years of age. The city of Houston has increased its exemption from $160,000 to $260,000. Okay, for exemptions amount for that category. Now, general overall school. Now, this is the state legislatures changes to your property taxes laws. The state legislator had changed the school general homestead exemptions from 25,000 then to 40,000, and then right now it sits at 100,000 exempt. Okay, so that means if your property value is at or less than 100,000, then that amount for the school taxes is exempt from taxation. Any amount over that is where the calculation begins. Okay. And as mentioned earlier in the appraisal district's presentation, there is the homestead exemptions for property owners that own their property not on the first of the year, but sometime mid-range of the year. They are allowed the prorated exemption from the date of purchase. So if you or someone that recently purchased the property, it's very important, ask them to complete that form. If they live in that property as their primary residence, please make sure to complete that partial exemptions request, immediate residential exemption request, because if you don't do it, you wait till next year, chances are you're leaving money on the table. Okay. And lastly, as far as impacting properties taxes for properties that are non-residential, this is mostly your commercial, anything that is non-residential. Could be your fleet, could be business property, could be minerals. As I say, anything that is appraised and is non-residential property, value less than $5 million, there is a limitation cap on the appraisal increase for that. So these are some of the changes. So look for the impact of that in your tax bill, which will be sent out within the next 2-3 weeks or so. We stagger them. Now, for me, the pictures tells 1,000 words. What are the changes or what are the difference if you don't file your exemptions? Well, this is an illustrations of a sample property within Harris County, within the limits of the city of Houston. As far as having an appraisal value of about $325,000. That's about our average market value for Houston around this time of the year. So we take that and we did some estimations on it. Okay. Now, for example, this property, if it has no homestead exemptions, no exemption whatsoever, it's just general property, general residence, but no homestead. Okay. You're looking at an average tax bill of a little bit over $7,400. Now, if this property were to be someone's house, they bought it and they moved into and they were living in it as their primary residence, all of a sudden, this $7,400 bill is shrunk now to about $5,500. Why? Because they filed the homestead exemption, and the homestead exemption can save you nearly 1/3 of that in taxes. Okay, now let's take this example a little bit further. if the property owner happens to be over 65 or disabled or a disabled veteran, or happens to be a surviving spouse of someone, and the surviving spouse is over 55 years old, and the surviving spouse has filed for the over 65 exemption, has filed for the homestead exemption, has completed all the paperwork. So same property, same scenario, you're looking at a tax bill that starts off with about 7,400, now becomes about 2,400. Okay, so nearly 2/3 of that value, that taxable, that tax bill has now been eliminated because the property owner qualifies for various exemptions. So, like I say, if you qualify for the exemption and you don't file it, it won't be given automatically. So it's worthwhile to look into it and complete the paperwork so that you get that exemptions that you may be entitled to. Okay, so complete the paperwork, follow through with the process. If you have questions about it, reach out to our office, reach out to the appraisal district. We'll be happy to walk you through that. Now, one of the benefits, if the property owner were to be over 65, disabled or disabled veterans, you unlocked a whole category, okay, of bonuses, for example, that you may be entitled to. For example, the first one would be the tax freeze. Okay, this is automatically once the property owner qualifies for the over 65 exemption, this is automatically attached to the property. And what that does, the tax freeze, is it freezes the school taxes for that property. Okay, and what it does is if the property value increases over the year, the taxes, the school portion of the taxes will not increase until that property sells, or that property, the property owner moves to another site and declares another house as their primary residence. But that tax freeze is important because it limits, actually, technically, it freezes the amount of taxes that you pay for your school portion of the taxes once you turn 65. So that's worthwhile, in looking into it, to completing your over 65 exemption application. The second benefit that may be unlocked by property owners who are over 65, disabled veterans, or a surviving spouse of anyone in that category that's over 55 years of age, is the tax deferral. And as Mabel had mentioned earlier in the appraisal district's presentation, a deferral is a postponement of taxes. It does not cancel your taxes, okay? Again, it's very important. When you file for a deferral, basically it is an affidavit that you file through the appraisal district, and along with all the required documentations that's there. Once that deferral is approved, it doesn't impact as far as how your taxes is calculated, in the sense that, we just code the account as deferred, and then if it comes up that, hey, there are taxes that are unpaid on that, instead of attaching the normal penalty and interest to the account, guess what? This deferred tax account only accrues a 5% per annum interest on whatever that's unpaid. Okay, so that's a bonus, because if you have a deferral on the account and you choose to pay your tax each year, you pay your taxes each year. There are no penalties, there are no interest, there are no assessments of extra fees. Okay, now, if for some reason you forget, or the budget is tight and you said, you know what, I can only pay 10% of this tax bill. Well, that 90%, instead of it accruing your normal interest, as if, February the 1st is when interest begins, delinquency begins, and at February the 1st, the delinquency rate is 7%. Instead of attaching 7% to that unpaid balance, your deferred taxes only has a 5% for the entire year. Okay, so like I say, the deferral ends at the change of ownership, or once the property is no longer in that person's name. Okay, and it's very important to emphasize, the deferral is not a cancellation of taxes. So if you have a mortgage on that account, very important, you reach out to the mortgage company, discuss this with us before you file the deferral, and if there's no problem with them, file the deferral. And, if you feel like you want to continue paying your taxes on normal, pay your taxes on normal. The deferral is there in case you need assistance in delaying or finding some time to make your payment for taxes. Now, what happened if you have unpaid taxes and you do need some more time to pay? No worries. Okay. You can contact the tax office. You can email us, or you can call us and say, hey guys, I have taxes that are due, and get me into a payment plan. Okay. We have flexible payment plans that range from 12 months all the way to 36 months. Okay. And you can start requesting this as early as February the 1st. And the point of having a payment plan is so that it avoids foreclosure. Okay. And it helps you structure the payment so that you don't accrue all of these unnecessary penalties and interest, as if you're like, hey, if I'm going to pay it every month, I'll make a payment. I don't need payment plan. Well, here's the thing. If you make a payment every month, the interest and the penalties on unpaid taxes continue to accumulate. It doesn't stop there. For example, as I mentioned before, delinquency begins February the 1st. Okay. So if you're making anything that is not paid as of February the 1st, accrues at 7% penalty and interest. Now move on to March. Anything that's not paid in March accrues penalty and interest of 9%. Okay. And then you go to April, becomes 11%. So, but if you're making you're reaching out to the tax office to do a payment plan, particularly if you just recently inherit a property, okay, and you realize that it has taxes owed on it. Don't just shove that piece of tax bill aside. Reach out to us, work with us so that we can have a formulation plan of sort for you, so you know how to tackle and manage the tax bill from this inherited property. Okay, it may be, hey, this is something that the siblings can get together and they can pay out. Or you say, hey, this tax bill is enormous. It has a deferral on there, or it has a tax, a tax deferral that's been for the last 30 years, or it may have a 2 years tax deferral, whatever the case may be. Once you inherit the property, or once you decide, to put this part of your estate, make sure you let the heirs know that there are taxes that are unpaid on that. So at least when they go to probate the estate, they know that tax is part of that equation, and that it is better to know and to manage than not knowing and then deciding what to manage. Okay, so reach out to us. We'll work with you. We'll provide you the information you need, and we'll help you to understand what is on your tax bill. Okay. Now, mentioned earlier about the benefits of having an over 65 exemptions. Part of that benefit is if you have that over 65 exemption on your account, and very importantly, it's not that you just file, but it's actually coded onto your account. Then when you get that tax bill that's being mailed out, probably by the end of this month, is you have a choice. You can, make, instead of paying the full bill, you can pay a quarter of that. It's the quarter payment plan. Okay. And this payment plan is afforded to property owners that are over 65, disabled veterans, or surviving spouse that is over 55 years of age, of any one of those owners category. You can pay a quarter of that bill without penalty and interest. Okay. So, for example, you received the tax bill at the end of October, or you received the tax bill maybe in sometime middle of December. Okay. Now, like I said before, January 31st is the last day to pay without penalty and interest. February the 1st is the first day of delinquency. But if you're the property owner and you have the over 65 exemption on your account, or coded onto your account, you can choose to pay the quarterly payment. And as long as your payments are made timely at the end of January, at the end of March, at the end of May, and at the end of July, there are no assessments of extra fees. Okay, so very important. If you're near 65, or you're you qualify if you're a disabled owner or you're disabled veterans or you're a surviving spouse that's over 55 years of age, of anyone in that category, it's very important that you follow through with the process to get your exemptions, because there's a lot of benefits that are provided to ownership of anyone in that category. And if you have questions about that, reach out to us. We'll be more than happy to explain and help you through the process. Okay. Now, for property owners that are not in the over 65 categories, what do you do? Well, don't worry. We have payment plans. We have various payment plans that can help you out. You know, for example, the very basics is the homestead plan. Of course, it goes from 12 months, there's 36 months, and you can wrap in the current year and the prior year that's in that. Now, what happens if you have rental properties? We also have payment plans for that. The goal of having a payment plan, as opposed to just paying it as you go along, is that the payment plan helps you keep the fees down, the penalties and interest fees down. Okay. And it also helps you avoid foreclosure actions. So very essential. Like I say, if you have questions about that to see how we can help you structure a payment plan, reach out to us. You know, we're here to help you. And if there are any information that I presented in there that you have further questions on, you know, tap them in the chat box or open up the mic and ask us. We'll do our best to help you. And, you know, if there's anything that we don't know as a partner team right here, I guarantee you, whether it be Nia or Lisa, you know, we'll find partners in our A Month of Service network that will have the answer to help you. And, you know, of course, for the tax office side, we can be reached at www.hctax.net. If you'd like to email us, it's tax.office@hctx.net. And if you'd like to give us a call, it's 713-274-8000. Now, let me put a reminder for you. If you haven't received your tax bill by, you know, mid-December or so, or if you feel like, hey, you should have been here, it's not here yet, don't panic. Just go online at www.hctax.net and just type in your address or your account number, and you can access your tax bill from there. Okay, so don't panic. Just because you didn't get a tax bill at the same time, doesn't mean you don't have to pay the taxes. Just check on our website just to be sure. Okay, and if you have any further questions, let us know. We'll do our best to help you. Again, thank you so much for spending time with us.
All right. Thank you very much, Jamie. I don't see any other questions in the chat. You guys are getting to be really, really thorough that folks don't have questions to put into the chat, but that's
We
okay.
have quiet people.
Quiet people. There were a couple questions that were sent to me in advance, though, however.
Someone just wrote,
Regina,
Miss Regina just wrote she had a question.
you would like to unmute yourself, or did you want to type it in? Okay, so she may be typing it in here.
Did you get any by email?
I'm sorry?
I think I interrupted you and you were going to say something about a question you got by email.
Yeah, I had gotten a couple of questions by email. At work this time, not driving. Okay. All right. First question. What options are available for retaining Medicaid insurance if an individual receives an inheritance?
That I am not a Medicaid expert by any point, but I know that if you receive certain public benefits, you need to be careful about receiving inheritance. I am not sure about Medicaid. I know that people on disability have to have any inheritances go through a trust. If it's a home, I'm not sure that it would affect Medicaid, but you need to talk to somebody who is a Medicaid, somebody who specializes in Medicaid.
Okay, and great that you even brought that up. Next Thursday, we are having a presentation about oh gosh, why did I just draw a blank just then? estate planning and long-term care planning and how it relates to public benefits and how it impacts public benefits.
That's
So
fabulous.
we are going to have the representatives, the one that you referred to me actually, Miss Lisa will be
A
presenting,
friend of mine, yeah.
Yes, ma'am. So they will be presenting next week. It is a consultant that works with a lot of the seniors and trying to help them with setting up and creating their retirement and their estate plans. And then the attorney, the elder law attorney, that's going to talk about what the legal requirements are and how to protect your assets when you're creating those estate plans, and how to protect yourself from
Whoever
Medicare.
asked that question needs to come next Thursday, because
Yeah, and
that's a friend of mine and she will know.
I did send her the flyer too. So
Great.
again, that's Thursday at 1 p.m.
Oh, Nia, is this a new to our lineup? Is this a new
No.
presentation?
No, this is one of the neighborhood recoveries that's part of our senior security series. So we've been all year long, we've been doing like retirement planning and retirement for seniors and talking about, what do you need to do to get started, and what if you get started late, and what does it actually look like, and making sure that you're actually financially prepared and being aware of planning like 401k benefits and how it impacts your social security benefits and withdrawing both at the same time, and what
My
does that
goodness,
actually
it
look
is
like?
never
So
too early to prepare for these things.
Yeah.
it is never too early. So we say it's part of senior security, but it's for everybody. It is definitely for everybody. So
Well, I'm
we
gonna
really
make
wanna-
time to join it because I need to learn more about that. I need
Okay,
to
Me
get
too.
myself ready.
I will definitely include the flyer when I send out the link of this recording to everybody as well.
Thank you.
You're welcome. Miss Mabel, this is okay.
What did Mabel say?
Thank you. She said we're all guilty.
I'm not available next Thursday, but I will definitely be watching that recording.
Okay, we'll do. Let's see.
It's always more fun if we have the interaction.
Yeah.
Yes,
Yeah.
I love it, because then it's like, hey, how does this apply to me? This is my case.
Next question here. If a decedent owns more than one property and the heirs agree to sell one of the properties without probate, would the affidavit of heirship transferring title to the heirs apply only to the real property being sold?
You would need to check with a title company. Some title companies are absolutely fine with using an affidavit of heirship before selling a home. Others will not let you do that unless the affidavit has been recorded for 5 years. So check with your title company, because if you can do it, that would be quick and save you a lot of money. But not every title company accepts them.
Okay. Ms. Regina's question here. I need clarification, please. An affidavit of heirship is for exemption purposes only. I need to clear title to a property in order to access the FEMA funds. The property incurred extensive damage during hurricane and derecho.
I think she means the
Correct.
derecho. Miss Regina, the affidavit of heirship applies for clearing title. I just always point out that in order to get exemptions, you need clear title. But in order to get the FEMA funds, affidavit of heirship is all you need.
So you should be good there.
She should be good.
Okay. Does that help, or was there an additional question? Okay. There was another one that was sent. Any possible relief from property taxes and fees that have been accruing for the last 4 years while the property was being litigated over first in family court and now in probate court?
That is a Jamie and Mabel question.
Wow.
My guess is probably
Next
not.
question. It's his own collections.
Okay, so I'll be very delicate to this. When it becomes part of the estate, usually if one of the heirs comes to us and say, hey, what do we do? Just as I put in my presentation that says, hey, when you get this, come to us, let's formulate a plan. The first thing I would have told this person is you have 180 days. Okay, if that property has a deferral on it, you have 180 days. Get all your brothers and sisters, get all the heirs, suck it up, go to the bank, get a loan, and pay this off. And then afterward, while it proceeds through the probate process, you can duke it out. At least you know the property taxes are paid for. Okay. However, it's been 4 years. Guess what? The first thing is any grace period, it would have vanished already. Okay. Second, after 180 days, on the 181st day, it would revert back to as if that property was delinquent on February the 1st of that original tax year. Okay. Yes, yes. And this brings to this point where I try to mention delicately, but it's hard. You know, if you're leaving an estate, if you're leaving a property for 2 kids, 3 kids, 5 kids, 12 kids, or 15 people, pick one person and name for that house, because that person will be responsible or should be responsible for the property tax. If you name more than one person, guess what? People will fight over who should have paid that tax. And the only person that will win, the only entity that will win in that fight of property taxes are the fees and the attorneys that collect those fees. Not even the tax office. It's the attorneys and the fees that are going to go pay them. So short answer, no, there is no reprieve from that. I am so sorry. My heart breaks.
Wow. Ms. Mabel, I
I
had a
have
question.
learned from these fine presentations of the tax office is that the best thing you can do if you're concerned about owing taxes, make a payment arrangement, make a payment plan with the tax office ASAP. They will work with you. If you make a payment plan before it gets sent to litigation, it will be much less expensive for you because attorney's fees won't be involved.
Right.
I had to go on cases where, you know, there are cases that I've worked with them for months and months and months, and I had to call the law firm at the last minute and say, hey, help me stall, even if it's just 1 more month. And they would do that, not because they like or because they see it's more viable to collect at a certain period than just to push forward for whether it be bankruptcy or for foreclosure. You know, we'll bend all over backward, you know, in compliance with the law to help you out, but we won't know unless any one of the property owners reach out to us and say, hey, I have a problem, I need help.
Wow. Okay. Ms. Mabel, I had a question for you in regards to the spouse, the exemption for surviving spouse. So and I want to make sure that I heard you correctly, or if I wasn't correct. You said that if you've got a person that's got an disability exemption, whatever kind of exemption, and you've got a spouse that has the spouse with the exemption has passed away. You got a surviving spouse. Does the surviving spouse have to be of a certain age to continue the exemption, or can they just apply for it because their spouse that passed had the exemption?
I see where you go. They have to be at least 55 when the spouse, when the partner the spouse passed away. And I guess I might have been a little cloudy in that with the over 55 surviving spouse exemption, there was a time 15, 20, 25 years ago when there wasn't much, people didn't have to put their ages on their forms that they turned into the appraisal district. So we may not know the age of the surviving spouse. It won't be on record. So when the spouse who is eligible for the exemption passes away, we encourage the surviving spouse to let us know, basically file the exemption again, just so that we can make sure we change the name over to them. However, as time has progressed over the years, we know more and more about what age the spouse is, because the newer forms, they have to put that on there. So in due course, we won't even need them to, we won't have to have them apply for the over 55 exemption. We're doing it now just to make sure we know that they're eligible for it. So I don't know if that makes it. We didn't have all the information before. So it's a good thing if you've owned that home for a fairly long time to go
Mhm.
ahead and submit that over 55 uh
By the spouse.
exemption paper for now.
Okay. All right. There was another question here. If property taxes have been were probated for over 20 years. No, I'm sorry. If a property has been probated for over 20 years and all taxing entities have updated their records to reflect the legal property owner, except the county tax office and the deed of records, what are the steps since the probate lawyer has passed and the firm has now gone out of business?
Ooh, I pass on that one.
Wait, let me make sure I understand correctly. So it's been probated.
20 years ago, but the county, the tax office and the deed itself still has not been updated.
For the deed itself, what should have happened is something called an executor's deed. And that's a special warranty deed where the executor, acting as the executor of the estate, transfers the property to whoever it is that inherits it. In terms of the county records, I don't know.
And they didn't do that. So, and since the attorney that did the probate is now deceased and the firm itself has gone out of business, how do they get that done?
They need to talk to either a probate lawyer or a real estate lawyer.
So they
I
still
would
have to have
imagine if you have the original court documents giving the transfer rights, whether it be to the executors or anyone, it would have that, whether this firm is in business or not, you know.
The court
I'm
records
just-
are still there, sure.
Yeah, exactly. If it's still there, it's just a matter of, are you willing to pursue that or not? You know, are you willing to sit down and explain? And actually, to change on the tax office side, it wouldn't be a change on the tax office side. It would be a change from on the appraisal district side, okay? And that, but what I'm not understanding clearly is you're saying all the other entities have changed the name except for the tax office. Well, here's the thing. All the other entities get their record updated from the appraisal district as well, too. You see, unless you're looking at a specific year, some 20 years ago, which we don't collect beyond, you know, a certain time period, that doesn't jive a lot on that. So I would
Go ahead, Jamie.
Yeah, no, I mean, I would look at the record that is that has been signed off into judgment, and then sit down with the attorneys, or if not, just call us up and say, hey, what do you have here? Can you guys help me with this? And approach it with the appraisal district to see if they can get the record changed from there. And then if not, reach out to the tax office, and you know, we'll be happy to tell you what happens or what should the next step be, you know, and if not, have an attorney help you evaluate that.
Well,
Yeah,
they're still going to do something to get the deed changed, though, regardless of the tax office. They still got to get the actual deed changed, and that's where I think she's saying you got to consult with
Go
the
to the
attorney.
executors, yeah.
because that's what we're gonna need, we're gonna need the deed or some sort of legal proof to change our records in the appraisal district.
So they have, even if they have the probated will that shows who the beneficiaries or who the executor should be.
No, because the executor needs to carry through what the will tells them to do.
Okay, so the will itself is not enough. They'd have
The will itself is not enough.
Okay, even though it's been probated.
Yeah, no, I mean, that's something they could show, but for the county, they would want an actual deed.
Okay. Okay, gotcha.
So the attorney dropped the ball there.
I've seen that a lot, even like with divorce cases and stuff like that, where people get divorced and somebody, you know, they get the house or whatever, but there's no extra step for the attorney to submit whatever.
I've heard of it too.
So what happens in that case, Lisa? What happened if the attorney passes away, and you know, what usually happens to that law firm, or who handles those cases?
Usually, hopefully they have a plan in place for somebody to take over the cases. Or, you know, that they retire and all their cases are closed. You know, we have to hope that they have some kind of plan in place. If not, some other attorney would have to take over everything.
Well, I have actually I have a client of mine, and then I actually have one person from one of our on-site workshop that tosses off to me is that a lawyer that had handled the case just, either we have cases where they've dumped the case saying, hey, I'm not representing you anymore, midway through, or they basically just passed away and didn't carry it through. And from my experience, my advice to these folks is, look, when you're looking for a lawyer, do not go as pricing. Okay. Do not look at pricing as your biggest factor. You're looking at competency, and you're looking at, are they willing to help you?
Because you're gonna pay
Because
for what you
pricing,
get.
you get what you pay for a lot of the time,
Absolutely.
So yeah, I've actually seen people cry about, well, he died and he left me this and I don't know what to do. And I was like, well, ooh, so yeah.
I had another question for you, Miss Lisa. Can you explain or kind of touch on when you've got multiple heirs for a property and they can't agree on what to do, and then someone can force the sale or forcing the sale of a property if all the other heirs, even if the other heirs don't agree?
That's a great question, and it's something that runs into problems a lot. When I worked at the Earl Carl Center, we would run into situations where none of the heirs wanted to give up their right of the property, but only one of the heirs was going to live on the property. And I would explain to them, somebody's going to have to pay the property taxes. And if they decide that the person living in it is responsible for the property taxes, they can come along and benefit from it later without having given any of those property taxes. The main thing is, if there are multiple people owning a home, even two people owning a home, if there is a disagreement, like one person wants to sell, the other person doesn't want to sell, they can go to court and get a case, and a case called a partition, and they can force the sale of the home. Because if it's property that can't be divided in half, if there's two owners, the judge is going to agree to sell the property because that's the only way you can divide it fairly.
The continuation from Ms. Regina's question, she says, initially, I was getting 100% of the affidavit of heirship since I am one of several heirs and the only one living on the property and paying the taxes. Here recently, my sister may have to relocate and live with me because she has been in and out of hospitals. Senior citizens were debilitating medical challenges. Does that change the 100% heirship status? If not, what changes in the percentage of heirship status?
Miss Regina, the only way you would get 100% heirship is if the other heirs would sign a deed giving you their share of the house. Just because you're the only one living in the home doesn't mean that you have 100%. It's, say there is 5 heirs, each of you has 20% of that home. The only way that it can work is you would do an affidavit of heirship that would transfer to all 5, and then the other 4 heirs would sign a deed giving you their 20% share of the house.
So the affidavit of heirship basically says, we agree that all of us are the beneficiaries, or we are now the new
Correct.
heirs, and however much percentages, whatever. It doesn't
Correct.
entitle one person more ownership than the other. It's just identifying, we have agreed that we're all the
These
heirs.
5 people are all the heirs.
All the heirs.
The only time somebody would have 100% heirship is if they were a surviving spouse or an only child. Otherwise, it goes to everybody in the next generation.
God forbid if one of them passes and then they have children.
It gets to be a real headache. We did,
Yeah.
back when I was at Earl Carl, we did a project for someone whose ancestor and something like 1908 bought property out in East Texas. And they were with Earl Carl longer than I was. I mean, it took years to get it cleared out because there were 40, 50 heirs because it had gone through so many generations without transferring title.
Ooh. Ooh.
Yeah, they ended up having to save money up and get someone, I don't know if it was a genealogist or what kind of, to trace all of the different family wings. It was a hot mess.
Wow.
Then it happened. They fixed it. It just took years.
And I'm pretty
the
sure
title from the Republic of Texas.
You know, it almost would be.
And I can imagine by the time you go back through all of those heirs and descendants, somebody's not going to just give up their share of something that, oh, I have ownership interest in this piece of property here. Oh no, I'm not giving mine up. I
That's
want to
what
keep mine.
happens. That's why an affidavit of heirship works, but the best thing is always the transfer on death deed and giving it to just a couple of people, preferably just one person, because if several people own land, there's a good chance there's going to be a dispute about it.
Lisa, that would, sounds like it would be a great ProPublica story.
It would be. I wish I knew somebody.
There's a segment, I believe it's on PBS. It says, "Where do you think you come from?"
That's the show's cool.
Maybe for next year we could do like a how do they trace that genealogy when they're trying to dispute property? Like what is that process like?
I have
So
never
this is
been,
what is it called? It's called Property CSI. Hey, I'll tune into that.
The Houston Public Library has a branch where you can do some historical research. I think it's in the old downtown library.
Yeah.
So maybe we could bring that up at the first of the year, or we can talk about that in our December meeting.
I can tell you in my previous life, doing oil and gas finance, I used to walk through a ranch with this landman, so to speak, to look for old telephone hubs. Okay.
Oh my gosh.
That was buried somewhere, just to mark that this is where they were starting the marks and bound of a drilling rig. They say 180 yards out from this postmark here, not a postmark, but this telephone hub. That's where they start doing the rig. I had to wear high boots and walk out there. I'm like, are you kidding me? Yeah.
Wow. Okay. I believe those are all of the questions that I had. Make sure, and I hope I got to address everyone's everything. I'm just double checking the social media pages to make sure I don't have any other questions there. And I do not. So with that being said, thank you all very much for joining us this afternoon, and thank you to our presenting partners with the Harris County Tax Office, the Harris Central Appraisal District, and the Texas Legal Services Center for you all for joining us this afternoon. And I see we did have Ms. Cecile with the City of Houston's Department of Neighborhoods that did join in a while back. Cecile, did you want to introduce yourself really quick? I'm not sure if you could hear us, and I know you generally tend to have issues with Zoom, so either kind of give us a thumbs up or something and kind of let us know if you can or cannot. But wanted to give you an opportunity to introduce yourself as well. Let's see, what else do we have coming up for next week? As far as our presentations go, we have evictions, Know Your Rights is going to be on Tuesday, the 19th. We have maintaining and adding value to your home on Wednesday, the 20th. And that's where we talk about the home maintenance and a licensed appraiser that's going to be actually on the call to kind of, or on the presentation to kind of give more information about what actually raises the appraised value of your home. And then Thursday, I was telling you guys about that senior security series about public benefits and long-term care planning and retirement planning and how that impacts your public benefits. So I'll be sure to send out the schedule for the remainder of the month along with that flyer. In addition to that, be on the lookout for another TOD, a transfer on death deed clinic that we intend to have in the next several weeks to come. And I will send out more information to everybody about that as well. The last one that we did went very, very well. So we had over 50 people that registered, and everybody, walked away extremely happy with what happened at that presentation. So, or at that clinic, and they were able to get their TODs executed and reviewed by attorneys and things like that at no charge. So, and thanks to the partners with Earl Carl and the city that helped get that completed as well. So, but we do intend on doing another one in the next several weeks. But we will be meeting in the next few weeks also to plan our 2025 workshops. At the end of this presentation, there will be a link for a survey. If you all could please take a little bit of time to just complete that quick survey and kind of let us know, what you think about all the presentations for the year. What would you like to see differently? If there are any issues that we have not addressed that may be impacting your family or your community, then please reach out to us and let us know so that we could see what we could do about possibly providing you all with that information. So we won't know what to plan until we get the feedback from the community or from people like you guys to let us know what exactly it is that you need. So we would definitely appreciate your feedback. We sincerely thank you and appreciate your support. For the month of December, we will have a very limited amount of classes or workshops that will be scheduled. So be on the lookout for a revised schedule for the month of December coming up as well. So with that being said, thank y'all very much. You all have a wonderful remainder of your day. Take care of yourselves and stay safe. And we will see y'all next time. And if we don't see y'all for the next couple of workshops, happy holidays to everybody. Eat well, enjoy the time with your family while you can. And let this presentation be a topic of conversation. That's be the perfect time to bring up about, planning for retirement years or planning for passing incapacity or what have you, because you'd be surprised at how many people just don't want to talk about it and have the conversation. But everybody's sitting at the table, somebody can talk about it and bring up something. Hey, I was on this presentation the other day. Did you guys see such and such? Or did you know that this could happen if possibly, what I mean? Just kind of bring it up in passing and kind of start the conversation, because it's important for everybody to at least have a conversation about it and not be afraid to talk about it. Because we know what's going to happen. It's inevitable. Everybody's going to pass away. We don't know when, we don't know how. And we need to make sure that we've got measures in place to make sure that our families and our property and your other assets are actually protected and go along and pass along to the person that you actually intended for it to go to.
That is a great idea, Nia. That is a great idea, because, you're sitting at the dinner table. My first question is going to say, hey, are you planning on giving me half a house? If that's the case, I don't want it.
That's true. It's too much trouble. People
Don't give me half a house, okay? Because it's going to end up me paying the whole bill. No, I don't want half a house.
People are so worried about offending somebody, but getting half a house or a quarter of a house is just going to lead to more trouble.
But you know what? Also, in addition to that, that will start to bring out people's true colors, and you'll see what kind of response you get from people, like who thinks that they are entitled to everything, or who really just doesn't want somebody else to have something.
Get a stupid car.
That will paint a clear picture.
Years.
If nothing, not to start family conflict or anything like that, God forbid that happens, but that will give you a clear picture as to, okay, now I know what I need to do.
That is an excellent point.
So, there you go.
Give me half a house. Give me a whole condo.
Minus the association fees, though. All right. You are welcome, Ms. Laura. Thank you for joining us this afternoon as well. Y'all have a wonderful remainder of your day and take care, and we will see y'all soon.
Thank you, everybody. Have a good afternoon, and happy Thanksgiving, because I won't be on one of these.
Lisa, I hope you got some notes for your presentation. Yes?
Yes.
Okay, awesome. Reach out to us if we can help, okay?
All right.
Thank you.
All right.